Herzlich willkommen auf dem YouTube-Kanal Dubai Recht klar mit Deria und Omar. Heute möchten wir über das lokale Arbeitsrecht sprechen in den VAE und über Arbeitsgerichtsprozesse. Und hierzu haben wir unsere Partnerkanzlei wieder eingeladen mit Darren. Thank you very much for joining this podcast.
Thank you for inviting me.
We are going to discuss some general topics about the labor law, but also about disputes and litigation. Let's start with the first question. What are some common labor law disputes that you can see more and more in the UAE?
That's quite an open question because the UAE is quite unique insofar as it doesn't have one simple system. The majority of the UAE is governed by the UAE federal law, which is law number 33 of 2021, which people are still calling the new labour law, mainly because it replaced the old labour law that had been in place for over 40 years. And then we have systems like the IFC, which has its complete own labour law, which was again amended recently. It came into force in 2019, but it's been amended recently in 2021 also. In both instances, I would argue that the most common complaint revolves around either illegal deductions from somebody's salary coupled with end of service benefit. They are by far the biggest amounts of litigation claims that go into the labour courts. There are still claims for unlawful termination, but generally, if those fall under what used to be what we called an Article 120 offence, better known as gross misconduct, and is now an Article 44, this is where an employer terminates the employee instantly without notice. Now, there's a little bit of a misunderstanding still out there, whereby employees are either reading something on the internet or misunderstanding something, whereby they think if they are terminated with notice or even without notice, there's a 3-month compensation that they can claim. Under the previous law, which has been repealed, it's gone, there was a provision that if somebody was terminated for something unrelated to their work, then there was scope to obtain an additional 3 months in compensation. The revised labour law has removed that. There is only one instance in real terms where you can get this enhanced compensation, and that is called for an illegitimate termination. Now, for a termination to be illegitimate, you have to either A, present a claim to the Ministry of Human Resources and be dismissed because of that, or B, you have taken a court case, which is generally a criminal claim, by the way, against your employer, which has subsequently been proven, and you've been terminated because of that. Then you can get the enhanced 3 months. Now, that's only for employees on the mainland or subject to the UAE federal law. DIFC is slightly different. And in DIFC, we're seeing a rise as more and more employees become aware of discrimination claims. For example.
Really? Discrimination claims means what exactly?
Well, both laws, both the federal law and the DIFC law, have now got full provisions for discrimination based on certain protected characteristics, as we like to say in English law. So in the UAE, we have sex, race, disability, national identity, age, maternity, pregnancy, and marriage. Those are protected characteristics, both in the DIFC and in federal law. The difference being, if you are subject to discrimination in the DIFC, you can present a claim to the DIFC and obtain compensation if it's subsequently found to be right. Yep. Under federal law, it's a criminal offence. It's not something that you can go to the labour courts and say, I've been discriminated against, give me some money, because there's no provision for that compensation, which is why that illegitimate termination clause is in the labour law. So you would present your racial discrimination or sexual discrimination claim to the appropriate authorities. They would take action against the employer under the penal code. If that's proven and you're dismissed, then you've got the claim for the illegitimate termination. So it's a little bit long-winded under the federal system rather than the DIFC. But another important thing to note about DIFC, if you have got one of these discrimination claims, the possible compensation includes what we call injury to feeling, which doesn't exist in the federal system. So on the federal system, you have to have proven losses. But in DIFC, it can be injury to feeling, even if you have no loss. So if you're discriminated against but not terminated, you can still be awarded up to 1 year's salary as injury to feeling.
Not bad.
Not bad at all. But don't go out discriminating. It's not a good idea.
I have one question. Let's assume I have been terminated. Before being terminated, I'm going to the Ministry of Mohre, Ministry of Human Resources, and I'm filing a complaint with them for whatsoever reason. Based on that, I'm getting terminated. Me as an employee, because I think that can be one of the challenges under the new law for employees to claim the compensation. So me as an employee, how would I be in the position to prove that this termination is based on me filing a complaint?
That is an incredibly good question because the burden of proof is on the employee. It's not on the employer to prove that you weren't terminated because of this for any other legitimate reason. And it's not as easy as it sounds for an employee to turn up and try to present proof. It is on the balance of probability still. So the employee's got to show 51% that they were terminated for this reason. But in a majority of cases, there may be evidence saying of poor performance or other issues. So it's not an easy hurdle for an employee to jump over. However, circumstantial evidence here is still evidence. The Ministry of Human Resources would say, well, it's a bit of a coincidence that they've raised a claim and then, 2 days later you've been dismissed.
Exactly, yeah.
And they would err on the side of caution. Generally, the presumption is if you're bringing the claim, the presumption is that, well, you're telling the truth.
An interesting case, actually. I think also for clients and future claims, that's a major topic.
And Darren, now we were talking about the claims when it comes to unlawful termination, especially in regards to the new labor law. What do you think in general about the new labor law? Does it grant the employee with more rights, or is it the other way around?
This is something that a lot of people have said to me, that the new labor law is terrible. It takes all rights away. And I wrote an article recently on this, whereby I'm not seeing that myself. The new labour law, realistically, has given us more rights as employees. Virtually everybody out there is an employee. So the first thing that we've got, which I think is vitally important, we can no longer be terminated instantly without notice during probation. There is now a notice period. This gives employees a little bit more stability because whilst you're on probation, you're not entitled to go on leave. Realistically, you're not entitled to sick leave. And a lot of employees get very upset over this. And we used to see, and there are some sort of nefarious companies out there who will hire somebody, and the moment they get to the end of probation, they will fire them. This notice period has helped that. That's one protection. As I mentioned earlier, we've got discrimination. We also have harassment protections and bullying protections within the law. Now, admittedly, some of those were in the previous law, but in the new law, they are clearly there. And not only are they clear, that they're clearly defined what amounts to bullying and harassment. Even being shouted at in front of colleagues and being demeaned or humiliated could amount to bullying. Now, admittedly, that's not something you can take to the Ministry of Human Resources, but it is something that offers you more protection than what you previously had. Everybody now, regardless how they're terminated, is entitled, if they've qualified for it after 1 year's service, end of service benefits. Now, under the previous law, if you were terminated for a gross misconduct offence, which is this Article 120, you forfeited your end of service. You didn't get it. Now, if you're terminated for a gross misconduct offence, the instant dismissal, you are entitled, regardless, to end of service. So that is another massive protection given to employees. And one of the biggest ones that everybody forgets, we now have different methodologies of working. So when I first came to the UAE, you could only work for one employer. If you work for a second employer, even if it was only for an hour, you were moonlighting. That was illegal. You could be facing serious sanctions. Now we've got the ability to work part-time. Admittedly, you still have to have 2 work permits, but you're no longer restricted. I personally have 2 jobs. I work full-time as a lawyer for Hussein Luta, and then on certain days of the week, I am a part-time law lecturer for one of the universities here. I have a work permit for both. Prior to the change in the law, I wouldn't have been able to be a part-time law lecturer. Not only that, we have now introduced flexible working time.